Yeah, folks back there, why don't you come up here and sit? There are seats up here and there are seats right here. I'm trying not to get my spit on you. I see a number of you have taken my sexual orientation in the law, or perhaps my law and religion seminar. Not to mention perhaps torts or PR, Justice Scalia comes up much less than those. But in the first two, you've heard a lot of what I've had to say about Justice Scalia. I'm really liberal. I'm really proud of it. I hate the fact that anybody would ever think that women have to apologize for that in this society.
I'm sorry.
Can't hear me?
Yeah, can you talk a little louder?
Thank you.
There we go. I'll stand right here. Is this working?
No.
Okay. Melt it out. What I was saying was, and I wish Professor Koenig were here, because he'll probably be surprised at what I'm going to say, some of the things I'm going to say. But in any event, I was just saying I'm very liberal, and I'm very proud of it, and I hate the fact that anybody should ever feel the need to apologize for that, particularly in this part of the country. It angers me deeply. I don't like a lot of what Justice Scalia did. I think toward the end of his career, he became a much more sarcastic, petty writer, which was disappointing to me for someone who had such great intellectual gifts. And I disagreed, as Professor Roeder does, with the vast majority of his positions. That being said, after John Lennon, Robin Williams, and David Bowie, this is only the fourth death of a public figure in my lifetime that has kept me up for several nights. If great is defined as influential, meaningful, important, characterizing a time and an era and a way of thinking, yes, he was great. And pound for pound, I would say the best logician the court has seen for decades. I can't presume to go back beyond maybe the 60s, 50s. I was at the investiture. The investiture is where, Latin for actually putting on the robes, where he was put on the DC Court of Appeals. I was a sophomore in college, interning at the DC Court of Appeals. And I remember this young Scalia guy who I'd never heard of coming in there with his 8, 9 kids. They were young and ill-behaved, and that inclined me in a positive direction toward him. Little did I know at that point that this would be someone who would live constantly in my head. I've had conversations and arguments and debates and in my head with Scalia a million times. I feel like I know this person. And so I'm very sad that he has passed. I always like to say that you guys should know every member on the Supreme Court and where they stand on those things, or you ought to learn it, or be embarrassed that you're in law school and don't know it. This is the Mount Olympus of our profession, and he was one of the great members of this Mount Olympus. Currently, and now no longer, the longest serving member of the court. The only person I would compare him to would be William Brennan, his counterbalance, the great liberal of the Warren Court years, from Brown versus Board of Education up through the civil rights advancements that the court had some connection to in the 50s, 60s, and sort of ending with the Rehnquist Court in the 70s, and the Berger Court. Excuse me, Berger before Rehnquist. But a couple of things about him personally that I really have always admired, before I get to the specific substance of a couple of the areas that I deal with. He wrote a law review article in the book that was published in the William and Mary Law Review a couple of years ago, arguing for the 3-year law school and saying, in fact, it ought to be 4. He took the law very seriously. He said, I wish I had learned intellectual property. I wish I had learned more about trusts and estates. I wish I had learned everything so that I could have been a better judge. Rather than say one of his greatest antagonists, Richard Posner on the 7th Circuit, who says 2 years or even less, it's a scam, and so on and so forth. Scalia took this very seriously as a great profession. There was a time when the clergy, the physician, and the lawyer were the 3 great professions. And with that came a lot of sexism and racism and other elitism in our society. But leaving those parts aside, one can still say that this is a great profession, it should be, and you should try to be great to be part of it. And he absolutely stood for that. And that's why, in some ways, I was disappointed near the end that I felt he started to act a little bit less professionally in his use of language when he could have done much more. But then my dad always tells me that the fact that I swear is an indictment of any ability I might have with language. So I obviously want to be careful with that. So I want to read you something that came from somebody somebody published in the Washington Post a couple days ago. When I was in law school, the Supreme Court clerkship was the holy grail for me. It was clerking, for me, excuse me, it was the holy grail for any law student. For me, it was clerking for Justice Antonin Scalia. Now that I'm a partner in a law firm that serves the notoriously progressive entertainment industry in Hollywood, the fact that I once clerked for Scalia often elicits looks of surprise from those sitting across from me who ask if I'm the functional equivalent of a unicorn, a conservative in Los Angeles, a place that Scalia had amusingly warned me would melt my brain. I tell them, no, I'm politically liberal, but that my time working for the justice was one of the defining experiences of my life. The job was a strange one in many ways. To assist in the writing of opinions, clerks have to get inside the justice's mind to think as they do and write as they would. My role was to facilitate his, and sometimes that was easier than others. In one case, I worked on writing a dissent, a position held by a minority of the court, with which I fundamentally disagreed on a moral level, but found as I wrote that I was drawn to Scalia's reasoning. His emphasis on precedents, strict textual construction, and judicial restraints. While I remain bound not to discuss details of the cases I worked on, I can say that Scalia's arguments in that case conveyed a clarity not found in the majority's opinion, which relied on legal and verbal gymnastics in order to reach the desired outcome. And if you know, for example, the sexual orientation cases, the four in which Scalia and Justice Kennedy have argued over the last 20 years, that's exactly the critique that people on the right make of what Justice Kennedy has done to nonetheless prevail and create rights for LGBT members of our society. And Justice Scalia would say, sounds nice and pretty, not logically sound. And to some degree, I would agree with that and say logically sound isn't always the only thing that matters. But he's right on that point. In any event, his approach had a logic and simplicity that resonated with me despite my politics. I found myself able to get inside his mind in that moment to sublimate my own views and write confidently in his voice. I was ever so proud when my co-clerk told me that Scalia had called it a knockout. There were other days, though, when I found myself sitting on Scalia's worn leather couch looking up at Leroy, the mounted elk's head that dominated the justice's chambers, wondering how both Leroy and I had gotten there, as Scalia and my three conservative co-clerks all found common ground that I simply could not access. You really think that? That can't be right, were refrains I often heard in response to bench memos I prepared in advance of oral argument. If there was a true surprise during my year clerking for Scalia, it was how little reference he made to political outcomes. What he cared about was the law, and where the words on the page took him. More than any one opinion, this will be his lasting contribution to legal thought. Whatever our beliefs, he forced lawyers and scholars to engage on his terms, textual analysis and original meaning. And I would say, to beat him, often they had to simply depart from his terms and do different terms, which he found objectionable because he was working logically in a very strict sense. But this is a discipline I value to this day. He always treated me with enormous respect and always seemed to value my opinion. He was also hands down the smartest person I've ever known. What would take me 2 weeks to understand would take him minutes to process. I'll never forget my first experience handing him an opinion and watching him in a matter of minutes type a few lines into his typewriter, yes, even in 2004, and instantly cut to the heart of the issue in a way that I'd simply been unable to do. He knew his own mind, and he taught me the importance of knowing mine. You have heard mention that I know my time is getting short, so I'm just going to say a couple things about substance. But you've heard mention that he was close friends with Justice Ginsburg, who was his political opposite. Their families were close. They vacationed together. When Justice Ginsburg's husband Marty died a few years back, and he had cooked a lot of meals for the Scalias and the Ginsburgs at holidays, Chief Justice Roberts read from the bench at the start of the new term that Justice Ginsburg's husband had passed. It was clearly evident that Justice Scalia was wiping tears from his face. So even though I don't like his positions in many ways, I really love the humanity of the guy. And the constancy and the depth of his voice and his utter, indisputable rhetorical brilliance. He did two things substantively that I'll mention in about 1 minute. One, along the lines of law and religion, in a very ironic sort of dance with Justice Brennan, whom I mentioned earlier. Justice Brennan was the one who wrote the famous Sherbert versus Werner opinion back in 1967, I believe, or was it 72? In any event, establishing the test that most states still want today, and that they put in the form of their RFRA laws, which is if somebody is exercising their right to do what they believe in religion, the only way we can allow a government, a state, a municipal, an ordinance or a law to burden that is if we can say it is very narrowly tailored and it really serves an important interest. I'm paraphrasing. That's the test that most conservatives want today. And yet in 1990, the direct opposite of that was produced by none other than the very religious and conservative versus the very liberal Brennan, Justice Scalia, who in the Smith case in 1990, the one about peyote in the name of religion, said, hey man, it might be part of your religion, but if it's a law that is passed to neutrally and without any specific targeting of a group, meant to generally enhance the welfare of the republic, and it's a legitimately passed law, we have to treat it as a neutral thing, and we want, ideally, for the law to be neutral. And so he stands at the center of a position that most religious conservatives object to, even though he himself is very much a religious conservative. And then in sexual orientation, as I said, he argued vociferously and bitterly with his close friend, once close friend, not as close now, but fellow Catholic, Justice Anthony Kennedy, from Romer versus Evans in 1996, to Lawrence versus Texas in 2003, to the Windsor case in 2013, to the Obergefell case last term. And in each case, he basically said, Tony Kennedy, you're finding ways to argue this because you believe it's right, and the country appears to believe it's right, but logically it doesn't follow from the principles that we are bound by our oath to follow. And in that, I would say his argument had integrity. It's one that I think should have been defeated. I'm glad it was, but I'll always have a lasting admiration for this man, and it will be very, very difficult, if at all possible, to fill his shoes. Thank you.
Oh, perfect. It's up here. It's up here.
Oh, there it is. Good afternoon, everybody. Nice to see you. My name is Professor McLaughlin, and I am happy to be here to talk to you and share with you a little bit of my thoughts regarding the passing of Justice Scalia, which was so sudden and very much saddens me. The thing I wanted to talk about with you today is the voice of Scalia and the fact that his voice is one that we recognize, that is one that I hear in my head when I read his dissents, one that is as if he's talking to me, and by the end of his opinion, it's like he's pounding his hand on the table, and he has gotten sort of this, gone to a crescendo of logic, but also of great use of language, to then end sort of where he began with his thesis or his overall assertion. And his voice is very much one of constitutional originalism, one very much trying to cabin in the Supreme Court, rein in those liberals who are trying to expand rights all over the place. And I think he served a very, very important role on our Supreme Court to help the court remain true to the constitutional, I guess, description of judicial power. And if we take a close look at the Obergefell case, we'll see that we can contrast back and forth. We can see the conversation between Justice Scalia and between Justice Kennedy. So I wanted to begin with the voice of Scalia and show you then how Kennedy replied. And we can almost see the opinions being distributed amongst the justices and revised in order for the justices to continue their debate back and forth regarding the proper role of the judiciary. So Obergefell was decided in 2015. It was one of the last cases, I suppose, that Justice Scalia heard and decided, other than this most recent term. And we can see Justice Scalia's originalism at work. We can see in the dissent, he sets up his first point. And his first point is that the United States Supreme Court, in deciding Obergefell, has created a fundamental right where none was originally intended, right? That is Justice Scalia's concern about substantive due process. It provides too much discretion to the court. Liberty is defined according to whoever is sitting on the bench. And so in Obergefell, he says, every state limited marriage to one man and one woman in 1868. No one doubted the constitutionality of doing so. It is unquestionable that the people who ratified the provision of the 14th Amendment did not understand it to prohibit a practice that remains universal and uncontroversial. He would say that resolves the case. There is no fundamental right here. There is rational basis review. This is in line. These rules outlining same-sex marriage are in line with history and tradition. Case closed. In direct response to this approach to the substantive due process clause of the 14th Amendment, we see Justice Kennedy replying directly in the Obergefell case. He takes a look, I believe, at the dissent, and perhaps he already knew, anticipating Justice Scalia's critique, and he gives us his voice, his understanding of the Constitution as a living document. And so he replies that the nature of injustice is that we may not always see it in our own times. He says that the 14th Amendment and our founding fathers did not presume to know the extent of freedom in all of its dimensions. They entrusted the Supreme Court, future generations, to charter and through this constitutional charter to protect the rights of all persons. When new insight reveals discord between the central premise of the fundamental rights that are protected, liberty, privacy, freedom with respect to intimate decisions, then he says a claim of liberty must be addressed. That is the distinction between the originalists. Don't go beyond the four corners right now. Look to history, look to tradition. Otherwise, substantive due process will and has run amok, versus the belief that the Constitution must be interpreted in accordance with changing times. Justice Scalia would say if it's a change that didn't exist, perhaps we can interpret the Constitution in a new way, but marriage certainly existed. The second example I have of how the originalist approach of Justice Scalia was given voice in the dissent and directly addressed by Justice Kennedy is this. Justice Scalia writes, the practice of constitutional revision by an unelected committee of 9, the Supreme Court, accompanied, as it is today, by extravagant praises of liberty, robs the people of the most important liberty interest, which is the freedom to govern themselves, right? This is the argument that he calls the Supreme Court as undertaking a putsch, a plotted revolt, an attempt to overthrow the government, to gain power and consolidate it in the federal court system, in the Supreme Court justices who sit for life, who are never thrown out of office by the electorate. This is one of the crucial critiques of substantive due process law when the courts begin to expand and find new fundamental rights. Justice Kennedy responds very directly to this criticism in Obergefell. An individual can invoke a right to constitutional protection when he or she is harmed, even when the broader public disagrees, and even if the legislature refuses to act. The idea of the Constitution was to withdraw from the people, withdraw from the subjects, from the vicissitudes of political controversy, that is, take it away from the majority, and place these fundamental rights beyond the reach of the majority and of the state, and to establish them as legal principles to be applied by the court. That is one of the important goals of the Supreme Court, is to intervene when the majority rules, even if we don't see an equal protection suspect class, when the majority rule is resulting in the deprivation of a fundamental right which the Constitution does not permit. So, when we think about this voice, this discussion, the conversation back and forth between Justice Scalia and Justice Kennedy, we see the counterpoint. We see the importance of balance. We see how Justice Scalia called the majority to account for its analysis and to justify the expansion of a fundamental right to groups that had not enjoyed that status in the past. And Justice Ginsburg would often say he made the court better. He made the opinions more precise. Justice Scalia disagreed with the way that Justice Kennedy arrived at the result, but Justice Kennedy was equally committed to his job to find within the Constitution whether or not a liberty interest was at stake. So I would say both sides, the strict constructionists, the originalists, and those who would say they belong to the living Constitution group of scholars, are trying to apply the Constitution as they have been asked to do through their appointment to the Supreme Court. They get there in very different ways, and right now we know that Justice Scalia is, I believe on Friday, tomorrow will be in repose at the Supreme Court. His voice has brought energy, precision, exactitude to the Supreme Court, and I think he made the court and all of the justices better. He invigorated originalism, and I believe that we will continue to hear his voice in our head when we read his dissents, and that his contribution will continue to give us insight to our understanding of these important issues. Thank you.
Hello, everyone.
still, maybe some folks, if you're sitting in the back, now that there's some empty seats, you can come forward. I won't take that personally that everybody's leaving right now. This is class time. I'm Professor Hopkins. I've taken a number of you all that I've had in class before and have now. And I'm going to talk about a particular issue. I want to talk about fathers and Justice Scalia's view of fathers and the parent-child relationship, father-child relationship, something that's near and dear to my heart. And I want to say a couple of things first about him. I'm also very saddened by his death. We're going to miss his voice. Just this last couple of weeks teaching the Obergefell case, and the case I want to talk about as well, Michael H., that I hope someday will be overturned, that Justice Scalia authored. The students in the class, a number of you all have said, these are page turners. These cases are page turners because he's such a wonderful writer. And Professor McLaughlin and I have talked about how reading Justice Scalia's dissent in particular, you need a dictionary in hand. He's just a brilliant, brilliant writer. So what I want to say is I also miss his passing right now because there was a glimmer in 2013 that he might have a different view of the father-child relationship than he had in 1989. So I'm going to talk about two cases in particular where in the one case he comes out against the father and finds that the father, biologically the father, has no rights, and then in the 2013 case where he's in dissent saying, what about this father? What about this father and his rights? So what I want to do is just let you know partly where my interest comes from is I wrote an article 6 or 7 years ago about the Supreme Court's kinship doctrine and talking about the fact that the kinship cases, the marriage cases, the parenthood cases are very much rooted in the cultural practices of white middle-class communities, and how looking at anthropologists' work in studying African-American communities in the United States, Japanese American communities, Navajo communities in the US, that there are very different cultural practices around family. And so part of which I hope that we will be seeing in the Supreme Court is an expanded view of what family structure is all about, compared with Justice Scalia's view of what he calls the unitary family. So I want to talk about this issue about fathers and parent-children relationship, talking first about the Michael H. case from 1989, and then about the Baby Veronica case dealing with the Indian Child Welfare Act in 2013. So for those who are not familiar, just briefly, the Michael H. case was followed on a decade, the 1970s, when the Supreme Court had developed all of its unmarried father's rights doctrine, believed with the rule that said an unmarried biological father has no protected fundamental right to parent unless he reaches out to seize the full responsibilities of parenthood, meaning supporting the child and creating a relationship with her. Then coming into the case a decade later, Michael H. in 1989, that was the law of the land. Michael H. were dealing with a jet-setting supermodel, international supermodel, married to an oil magnate, basically, and the wife tends to like to have relationships with people outside of marriage. So she has an affair, has a couple of affairs actually, but one affair in particular with Michael H., the name on the case, and they have a child together. And Michael H. does what he's supposed to do. He creates a relationship with his child, pays for her, lives with her and the mother for a while as well. So supposedly protected by the existing law. Not he wasn't doing it for that reason, he was doing it because he was a good father and he wanted a relationship with her. And what happens is Carol, the also faithful wife, gets back together with her husband and they file a suit. The husband intervenes in a custody paternity case where Michael H. is trying to get visitation rights, and the husband asserts a special law that most states have, a marital privilege or a marital presumption that a child born to an intact marriage, people who are married, is a child of that marriage. And so we see competing rights holders, Michael H. with his right to a fundamental right to parent, possibly coming up against this marital presumption that protects the marital family from interveners coming in and making claims to the children going to the wife of the marriage. And in that case, Justice Scalia authors the opinion, and he finds that Michael H. has no fundamental right to parent. And the way he does it is how he characterizes the issue. He ties into things that folks have talked about, of saying if we're going to expand fundamental rights, we have to look at them in the most narrow way possible, so that we don't have that expanding new liberal approach to all of these rights out there. And so he characterizes the right that Michael H. is asserting is the right of an adulterous man to parent his child. And of course, if you look in laws and you look in history and tradition issue, you're going to look back, and of course there are no laws in the books that say adulterers are entitled to parental rights, right? Once you characterize the right in that way, then that's the end game. So what I want to say is it's a plurality opinion, meaning that you didn't have a majority opinion here. This is a case I think I was hoping that would come before the court again and might, like Bowers, eventually have enough votes to overturn it. Because we didn't have a full majority there. What we have is a competing interest of the cuckolded husband against, say, the cuckold or the biological dad. And in this case, Justice Brennan, in dissent, talks about changing times, and that Justice Scalia is not recognizing that we have changing times and changing demographics. And so I say that because in 1989, that was already part of the dialogue, and now we come to 2013 in, in the Baby Veronica case. But I just want to say a couple of quotes from the Michael H. case that come up. One of them is, he says, "Law, like nature itself, makes no provision for dual fatherhood." And I open up the question to you all in terms of cultural groups and people that you know, where you have multiple people who are parent-like figures in a child's life, step-parents, blended families, other kinds of things like that. And in this particular case, the daughter was also seeking to have a relationship with both of her fathers, people she viewed as both of her fathers. He's very clear in the case about all of the rights that flow once you have a right to parent, once you have parenthood, legal parenthood status, all kinds of things. So he recognizes the importance of parents and their relationship with their children, and yet he holds up the marital family as sacrosanct, and that one is the one that wins the day. And so Michael H. loses all rights to his child. This child he has a relationship, a child who wants to have a relationship with him. And in so doing, he refers to those other unmarried father's rights cases and that rule that biological relationship plus reaching out to seize the responsibilities of family, responsibilities of parenthood, are all about this unitary family. And so this is consistent with it, except that the unitary family here is the non-biological father, the marital family at issue in that case. So with that, I just want to add, excuse me, the discussion of the other case, which is the Baby Veronica or adoptive couple versus baby girl case. And you might or might not have heard about this one. It's a case based on the Indian Child Welfare Act, where Native American tribes and Native American parents have extra rights to their procedural rights as well as substantive protections in contests. In this case was an adoption case. And basically, you might have seen it in the news, you had a couple that were engaged. She got pregnant. She was Hispanic. He was part Native American and Hispanic, and they were engaged, and she decided to break off the engagement. And then she went off. He was in the military. He was deployed to Iraq, and right before he was deployed, she served him with papers that were showing that she was giving up the child for adoption to another couple. And so he immediately sought a lawyer, intervened in the case, goes all the way up to the Supreme Court, and he had won below. He was given custody below. And then it goes up to the Supreme Court, and Justice Roberts writes the opinion, and the adoptive couple wins. Justice Scalia dissents with Justice Sotomayor and Justice Ginsburg and Justice Kagan. A very unusual political alliance, wouldn't you say, right? Yeah. But what I wanted to say is he's got a very short opinion of his own, and this is the glimmer of hope that I was really looking forward to hearing what he had to say should Michael H. be revisited going forward. He says something, very short opinion, dissenting about disagreeing with some of the reasoning in one of the in the other dissent, and then he says, "While I'm at it, I will add one thought. The court's opinion, it seems to me, needlessly demeans the rights of parenthood. It has been a constant practice of the common law to respect the entitlement to those who bring a child into the world to raise that child." Does that sound like what he said in Michael Age? Not a bit of it, not a bit of it, right? So I wonder whether maybe he's had a change of mind, right? Maybe he's sort of come forward with the times, maybe, maybe not. Excuse me. We do not inquire whether leaving a child with his parents is in the best interest of the child. It sometimes is not. He would be better off raised by someone else. But parents have their rights no less than children do. This father wants to raise his daughter, and the statute amply protects his right to do so. There's no reason in law or policy to dilute that protection. I see a glimmer of hope, and we will not see what his view would be should this issue come forward. So saddened about this particular issue, but also very saddened that we won't hear his voice and his wonderful writing going forward. Thank you all.